Welcome to Lawyer and Layman Explain It. This is a show where we discuss topics related to law and social justice from the perspective of a layperson who is never prepared, especially to speak on legal topics, but has plenty of candy to help out. And
someone who occasionally has to fight the urge to critique the improper form of objections that are made during legal dramas. Like, Kasey, come on. SVU, like, we need to talk, because sometimes you're over-objecting, sometimes you're under-objecting. I'm trying to turn it off because I'm just really there for my girl Olivia. Yeah, it's hard to turn lawyer brain off. Before we dive into our episode, quick disclaimer. This podcast is for educational purposes only and is not intended to provide any legal advice. If you need legal advice, you might want to pause this podcast and find a lawyer.
But then come back. Please come back.
Any inaccuracies are unintentional, and facts could change at any time. Do your own research.
You're listening to part 3 of the Supreme Court History and Origin Story episodes. If you haven't listened to part 1 and part 2, we recommend going back and listening to those first.
Thank you, Martin, for that plug for the prior 2 episodes. Yes, we highly recommend going back to listen. Mostly because, Martin, we had some warm and fuzzies during the last episode talking about the Warren Court. How ready are you for today's discussion, though? Do you have a stress ball or something, some coping thing with you?
Ooh, how ready am I? I don't know. No stress balls. I did think about stealing your stress ball, similarly to how the conservatives stole the court. Oh, my gosh. I guess there's still a lot to be said about even all the topics that we covered in the first 2 parts. So yes, I don't think I can be ready, but I do have Sour Patches. Last time, I think I referenced Reese's Pieces or Reese's.
One of the prior times. Yes.
Yes.
Sometimes you just need candies to get you through.
Yeah, this time it's a switch up to more like it's not really fruit so much as it's just sugar. But yeah, Sour Patches will help.
All right, so let's shift gears and talk about the Rehnquist Court. That is the court that was led by the Chief Justice before our current Chief Justice. Martin, do you know anything about William Rehnquist?
Yes, I do. In full disclosure to the audience, I kind of cheated. I've been reading a book, Supreme Inequality, by Adam Cohen, that talks about basically the last 50 years of the Supreme Court. So I really cheated. But I think before reading the book, again, if you know Supreme Court justice, I feel like it's either for very good reasons or much more likely for very bad reasons. And
True.
Rehnquist kind of elicits a negative feeling, but especially now that I know some facts. Yeah, I do know a little bit, I guess.
So this is perfect. I think that's going to make our discussion even richer. So awesome. And we will, for our listeners, share the resource, the Supreme Inequality book, in our resources that are linked in the show notes. Martin, even though you have come to the episode prepared, I'm going to ask you to read this excerpt from the Supreme Court Historical Society to help out our audience who may be less familiar with Justice Rehnquist.
Yeah, I think unfortunately I am more prepared because I might get sick reading this, but okay, let's see. William Hubbs Rehnquist was born in Milwaukee, Wisconsin, October 1, 1924. He grew up in the suburb of Shorewood. The son of a paper salesman, Rehnquist's strongly conservative views can be traced directly to his childhood. According to a Washington Post report, the political heroes in the Rehnquist household were, quote, Republican standard bearers such as Alf Landon, Wendell Willkie, and Herbert Hoover. When Rehnquist was asked during the Democratic administration of Franklin D. Roosevelt by his elementary teacher about his career plans, he replied, quote, I'm going to change the government. Ugh.
So, Martin, you've already given a very visceral reaction. But what's your guess? I mean, do you think he made good on his promise to change the government? And also share any other reactions you have to all of that you just read.
Yeah, the was not part of the quote. That was my reaction. And yes, he did have quite a role in changing the government. He sought out. He had a whole lot of help changing the government too. Yeah, I don't know how much we can get into, how much time we got.
It sounds like there's more there that you want to share. You have reactions to the book you've been reading.
Yeah, I mean, really, because the way that Warren exited and the court changed is frightening and actually had a huge impact on changing the government. I guess I don't know if I can rant, but to catch the audience up on what happened, Lyndon B. Johnson wasn't running for re-election. However, the court and his administration, I think, made a pretty decent amount of progress within civil rights. And in fact, in the book Supreme Inequality, Adam Cohen kind of describes how the court itself was moving towards protecting poor people, particularly as what's known as a suspect class, which means typically the court will interpret laws impacting a suspect class in different ways, I guess, like in a snapshot. Kasey's nodding your head.
I am nodding. Correct.
Okay. As a layman, I need to consult my legal counsel. So they knew LBJ was sitting the second term out. And Warren kind of understood the makeup of the court and didn't, also probably wanted to protect his legacy with some of the progress that they made. They ended up nominating, I guess LBJ nominated a replacement. I believe his name was Fortes, and Nixon, who ran on changing the court as well, changing the government as well, kind of ran a campaign on getting rid of the liberal justices. And Nixon drummed up this media frenzy about his potentially corrupt connections to some private wealthy individuals, and anyway scared the Senate off. I believe Fortas was on the court already, but they were nominating him for Chief Justice. Who?
Okay, I'm learning something. This time I'm nodding as I am learning phase.
You saying that makes me want to give the disclaimer. Again, a layman who just kind of read this book, part of this book, actually. So anyway, he does not get confirmed. There's an open seat as LBJ passes the torch. Nixon wins, and he immediately begins, him and his administration, his attorney general, and his Justice Department really go after the court. So they continue to pressure Fortas, and even I think got to Warren and potentially threatened his legacy. And I think Fortas eventually resigned. All that being said, what I really remember was there was this very clear, I don't want to say conspiracy because I think they did it somewhat openly, but there's a clear direction and priority of the Nixon administration to turn the court and really to favor corporations and private business interests. Oh gosh, where do we even go? How much time do we have left still? I feel like we got more here. But seeing that they changed the government was crazy, because I guess to sum up what happened, the court was kind of living up to the ideals, which rarely, I think, in the history of our country has it really lived up to these ideals for everyone. At least the ideals that we see that some of us agree on today. Mm-hmm. And the court kind of was taking this turn to make progress towards minorities. And they did. And they began to look at these social causes protecting poor people, disadvantaged people, disabled people who were on welfare programs. And they completely changed the court to being anti-welfare,
lifting people out of poverty.
Exactly. And in fact, started siding with the corporations, which resulted in the alarmingly high and increasing wage gap we have in the country. Yes, this court did change the government and had an impact on the country in a wild amount of ways, and still to this day.
So I'd like our listeners to know that Martin said all of that with no notes. So I guess the podcast might need to be retitled "Layman Explains It All." I mean, I had very little to add, and I'm super impressed that Martin was able to recall all of that with such gusto. I think it speaks to how important these issues covered in supreme inequality are to all of us. You do not have to be a lawyer to recognize the impact that the Supreme Court has on our lives every single day. And the things that we find difficult and challenging when people go to the gas pump and they're like, these prices, or they work and collect a paycheck and they're wondering, why are there so many taxes taken out? So many of these things can be traced back to, hey, how has Supreme Court precedent evolved? So truly, listeners, we appreciate you tuning into our podcast, and we encourage you to gather up as much information as you can through this Adam Cohen book and through so many other resources that are out there to learn about the Supreme Court. Martin, thank you for answering my question. And we're going to jump into a couple points of the Rehnquist Court, but I did want to flag for listeners. So the Warren Court transitioned to the Burger Court. And we don't talk about the Burger Court here for a number of reasons, mostly time. But Martin points out that the sort of shift in political agenda began after the Warren Court's conclusion and when the Burger Court commenced. So while the Burger Court is still regarded as somewhat liberal, I think the shifts began to take place and then kind of laid the framework and the groundwork for the Rehnquist Court. So with that, Martin, I do want to share with you that there was an important free speech case that came out of the Rehnquist Court that many regard as a point of progress. You might be familiar with this from reading the book, but are you familiar with Texas versus Johnson? Does that sound familiar to you at all?
Not specifically, no.
Granted, very generic name. And I mean, Texas
has been involved a lot of Supreme Court cases. Yeah.
Yes.
So,
right. So in Texas versus Johnson, the Supreme Court overturned the conviction of a man who burned the flag in protest and claimed that he was engaging in symbolic speech. And notably, at the time, he was protesting President Reagan's policies. Martin, do you think that was a unanimous decision or a split one? And the reason I'm asking you is, do you think that by the time we got to the Rehnquist Court, all the judges were like, you know what, yeah, this guy has a point? Or do you think that there was the sort of split that we've talked about in cases like Shelby County and others?
Ooh, this is harder now that I have a little bit of background in that transition between the Warren, to the Berger, to, is it Burger?
Burger.
Okay. To the
That's
hamburger.
how I learned it, at least.
I mean, it's easy to, I didn't want to say hamburger, but then I did. So it is easy to remember. So yeah, from the transition from the Warren Court to the Burger Court to the Rehnquist Court. It's right in the middle. I think before I read the book, I would probably say it was not unanimous just because it feels like the court has been politicized for so long. And I think that transition is kind of where the politicization really kicked off, I guess. I don't know. Again, however, after reading, I do know, I don't know if it was the Rehnquist or the Burger Court, but the court did also have another case about burning draft cards.
There was, yes, the draft card burning case, which I don't have in my notes, but I know you and I had talked about outside of the podcast. So based on what you learned about that case, does that inform you, or was this unanimous, or was this split thinking?
Yes, it makes it hard though, because that case, if I recall correctly, was 8-1. I remember there was one dissent. And I'm curious how much the details of these cases will be overlapped. But I want to say, surprise answer, it was unanimous.
Interesting guess. And it was a 5-4 split.
Ooh, so the opposite.
I mean, but when you think about it, though, so I don't have the details of the draft card case readily available. And for listeners who want to learn more about Texas versus Johnson, we will link to some summaries. But keep in mind, a draft card is this smaller thing, right? Whereas the flag has so much emotion and, for many people, patriotism attached. So you could imagine that there may be more agreement, and there was more agreement that it could be suitable to have a sort of political protest that multiple of the justices, that the majority of the justices could get behind, involving the burning of draft cards. Whereas the flag, I mean, justices have been and probably continue to be very sensitive about the topic of the flag generally.
Yeah, the
flag.
Yes,
it was a 5-4 split.
Yeah, that makes sense. I mean, the flag is a symbol of the country itself, and that's what flags are in general. And there definitely is a lot of um, affinity for the American flag. Okay, let's break it down. Let's break it down. It was 5-4 ultimately, but just a quick Google search. Johnson was tried and convicted under a Texas law outlawing flag desecration, sentenced to 1 year in jail and assessed a $2,000 fine. And then when it made it to the Supreme Court, it was overturned and the man was set free, or his conviction was upheld.
His conviction was overturned. So yes,
okay.
He was set free.
Oh, that's surprising, especially I guess, if you have the political lens that we have nowadays, you would think that a court that was turning in, I think at the time, probably was it the Burger? Of course, I mean, either way, it was a majority conservative. You would think that they would have upheld a man being convicted for flag burning, but
you see, it's a very narrow majority that carried the case, right? 5-4.
Yep.
If we transport ourselves back in time, you can imagine there were probably some very heated decisions of people being like, that if we do this, it means that people are going to see that there are some instances in which you can burn the flag. And then the other people in the majority were like, yeah, duh, we thought about that. So, but yes, it was not a near unanimous or unanimous decision for exactly the reasons you point out.
And I'm curious, like, what was the legal theory or reasoning behind? Because of course they challenged free speech, right? First Amendment.
Yes, it was a free speech case, and I'm looking at a great resource. It's uscourts.gov that has a number of pieces of information about the various courts around the country, but also about some Supreme Court decisions. And a summary of the reasoning is that the majority of the courts agree with Johnson and held that flag burning constitutes a form of symbolic speech that's protected by the First Amendment. The majority noted that freedom of speech protects actions that society may find very offensive, but society's outrage alone is not justification for suppressing free speech.
No, that's interesting. I wonder because, Supreme Court cases, depending on what they decide, and I think historically they typically try not to decide on constitutionality, right? They're like those are the biggest and weightiest argument because the ramifications, right, open up potentially floodgates. Or
yes, right. I had to think about that for a moment. I was like, okay, transport myself back to con law, but that does ring a bell. I do recall us discussing the idea that the Supreme Court treads carefully around constitutional questions, and if there's other questions, particularly with regard to cases that were decided by a state Supreme Court or where there was very contentious appellate history, I think sometimes courts will say, well, maybe this piece was decided wrong below, and let's, we've seen in our prior discussions, let's reverse and remand so that they apply on these lines. And it does sound right. I'd have to go back and sort of look into more Supreme Court jurisprudence and theory related, but I think you're right that the court, I think sometimes if they don't need to get to the constitutional questions, they won't, because they recognize the implications of the decision on that, interpreting that particular part of the Constitution. Anyone, again, who practices before the Supreme Court, if we are wrong, write in, contact us on socials, because this is not the area of law I practice. Sorry, Martin.
And as we say, don't walk around not knowing.
Don't walk around not knowing. Exactly right.
So make sure when we're telling people something that they are knowing what's
the right thing. Yes.
The correct way.
Exactly right.
Yeah, I just Googled it. I understand. Like, I thought that there was like a theory or practice, but it's a doctrine, constitutional avoidance.
That definitely rings a bell. Yep.
Yep. That federal court should refuse to rule on a constitutional issue if it can be resolved involving constitutionality, which makes sense because a constitutional decision, it doesn't go higher than that, right? That's the end all be all.
That's right. And the Supreme Court is like the venerated, trusted body to be interpreting the Constitution. So yeah, that's correct.
Right. And so they don't want to do that because if they can find another reason or another law to use to interpret it, I think it kind of leaves it open for the future, for it to be, only necessary to have such a serious constitutional decision to be made. In that case, it makes sense. But knowing the court's history, does it happen that way, or does it only happen when they want to? Right? Like, when is it?
Well, I mean,
to wrong constitutionality, when they have the opportunity to, they will. Do they always do that? Not necessarily.
Yeah, the question of Supreme Court consistency, that's probably a topic for its own podcast, because again, these people are not isolated from the outside world or from backgrounds and experiences and political parties that they've been deeply entrenched in before joining the bench. But
do you mean that these are people? No.
Human beings, potentially biased, imperfect human beings. Shocker. But to your point, I mean, keep in mind that there's also other ways that law is made, right? So you've got state laws, you've got statutes, you've got ordinances. Many of these things could be at play in addition to the other sort of like, hey, we have a federal statute, but then also we're saying this is a Fourth Amendment issue. And maybe the Supreme Court might, for all the reasons you point out that support the constitutional avoidance theory, they might focus on the statutory question. So yes, it is fascinating. And I think these are like very much the conversations we had in law school about like not just the substance of a particular decision, but how does the Supreme Court work? Why do they decide in these ways? Why are their opinions written in such ways? And also plug for our last episode, I think it was our last episode, where we kind of pick apart a Supreme Court case and all its various pieces. All these structures are in place by design so that the Supreme Court functions in such a way.
Right, it's kind of rules for how the game's supposed to be played, and Supreme Court's supposed to interpret those rules like an umpire. They're not supposed to swing at balls, which I think one of the justices made a quote.
That sounds so familiar.
I'm totally stealing that from the book. We'll have to.
Should we look it up?
Yeah, sure. And the other thing I was going to say, like in that same vein too, is when they ruled that it was free speech to burn a flag, like that's really interesting. Like, is it just specifically burning a flag, or it sounds like in the court, and I think the quote that you saw from the Court.gov, U.S. Court.gov website, is that the right website?
Correct. U.S. Court.gov. Yeah.
It sounded like they interpreted, or they left the door open for other speech or acts of speech that society deems inoffensive also being protected. So it's interesting. There's always these details, and how narrow or focused is the decision? What do they put in writing? But also, I think, as we've learned in recent times, sometimes doesn't seem to matter at all.
Then there's that. So the saying that you are recalling is, from what the internet tells me, and I might not be finding the right thing, but it looks like it's a Roberts quote.
Yeah.
Yep, we're finding the same thing.
Yep.
So does that take away your level of excitement for remembering?
Yeah, I mean, yes, it does.
I mean, the language, but the language is what it is. Like, I mean,
I think it's a good quote. I think in classic Robert fashion, like pot and kettle. Like,
well,
so do we want to? What was the context, right? Right. Okay. So he presented this metaphor to the Senate Judiciary Committee at a hearing on his confirmation to be Chief Justice of the United States. Oh God, it was when he was trying to be Chief Justice. Okay, right. Which also was kind of a controversial thing, right? It was HW or was it W? But either way, it was one of the Bushes, and he was already nominated to fill an opening. Maybe it was Reagan.
No, younger Bush, because Rehnquist. I'm sorry, the Roberts Court. He became Chief Justice in 2005, 2006.
Okay. So yeah, G-Dub already had him nominated to one of the openings, and then I think another Supreme Court justice either stepped down or sadly passed away, and so he switched it up, said no, Roberts actually is going to be chief, and then brought in, was it Senator O'Connor or whoever? I don't know. Whoever he had next. Was O'Connor already there? I don't know. I'm nervous about saying these things out loud because I say names as if I know them, but I don't know them enough. Okay, so I guess to get back to it, right?
So he made the statement at his confirmation hearing.
Quote, "It's my job to call balls and strikes."
There's more to it. Wait, he also said, again, uscourts.gov coming in super clutch, coming in handy. There's more to it. So the part that I see quoted, and we'll link to this page, starts with an ellipsis. So there was more, and probably the part that Martin read. Judges and justices are servants of the law, not the other way around. Judges are like umpires. Umpires don't make the rules, they apply them. The role of an umpire and a judge is critical. They make sure everybody plays by the rules, but it is a limited role. Nobody ever went to a ball game to see the umpire.
Oh, that's interesting. So I have another one that finishes that one. It's from CNN. So actually, when I click at the webpage, it goes down. It's also dated.
I saw that too, actually.
From 2005.
So the internet is not a perfect place, people. This is another reason why you have to do your own research. Just because a link looks like it exists, it may not actually exist. Please carry on.
I'm glad that you found the US courts.gov, because that I will definitely say, oh, actually, okay. I find the same quote, I believe. It is later in that link from uscourts.gov.
Okay.
And yes, he says, okay, I guess I'll give the full sentence that he used. "I'll be open to the considered views of my colleagues on the bench, and I will decide every case based on the record, according to the rule of law, without fear or favor, to the best of my ability. And I'll remember that it's my job to call balls and strikes and not to pitch or bat."
I know you want to react to this, Martin.
Physically sick reading that.
I know you want to react, Martin. And I want you to react, but we are going to have an entire episode/set of episodes on the modern Supreme Court. Just keep that in mind, because there's a lot to be said about my man, Chief Justice Roberts. Okay. But yes, please, since you've read this, since you brought this up for our audience, you have thoughts. So please share them.
Yeah. I guess as we said earlier, it is a really good quote in its content. Mm-hmm. However, the context of being said by Roberts is, like I said, it's kind of making me physically ill. I think that's correct. I think that is right. Judges are not supposed to be pitching or batting or signaling to teams that they're going to do such and such, or giving favorability to certain teams. They should not.
The favor part stands out. Yeah. Mm-hmm.
Like, if the rules are the rules, the facts are the facts.
The cheese tax heads out there will understand.
If you know, you know. I mean, he even says it, right? He decides every case based on the record according to the rule of law. And I bet you in our next episode we'll have some examples where that might not have occurred. Leave it at that.
And this is why, listeners, you have to stay tuning in, because there's so much more. This onion has many layers. So, Martin, since our episode is getting long, and there's so much to the Rehnquist Court, but we can't cover it all, I wanted to start with something that we might feel good about, this advancement in free speech. But as you are well aware, the Rehnquist Court decisions also largely scaled back civil and voting rights and set very high standards for claims of discrimination to be successful. Martin, does that surprise
you? One word, no. No.
So, without getting into a ton of detail about many other interesting, fascinating cases, I want to talk about a little case called Bush versus Gore. Martin, do you remember what that case was about?
Hanging chads or whatever. Yes, it was disputing election results, specifically in Florida. And yeah, how much more detail?
No, that's perfect. That's a great start. And also, listeners, a lot of this we're like somewhat recently coming to awareness about, because I mean, we were in like elementary school when Bush versus Gore was actually happening. But yes, so hotly contested presidential election. Florida was a critical battleground, as it often is, for electoral college votes. And Gore challenged the number of votes that Bush received, demanded a recount. Bush claimed that a recount was unnecessary. Supreme Court ultimately sided with Bush, and Bush became our president. And this glosses over so much. As usual, there's a whole long opinion. So listeners, we always say, do your own research. We will link to some resources in our show notes to help you out. There's a lot of coverage on this. And in fact, there's an interesting, fairly recent CNN article that points out how Rehnquist, who wrote a concurrence in the case, not the majority opinion, but a concurrence. So he agreed with the outcome, but had his own rationale. He tried to advance a theory that would, quote, give complete power to state legislatures to control election processes at the expense of state courts, ensuring constitutional protections. I've said a lot there, so Martin, you can either react to the Bush versus Gore recap or this theory that Rehnquist advanced in his concurrence. But what are your thoughts?
I will say it is as interesting as you mentioned. We were in grade school, so it seems relatively recent history, but it was also something that we kind of like lived through, and I guess in our adult lives learn more about. And it's, as you said, there's a ton of stuff here, and actually a lot of familiar faces and names that will probably come up again in our next episode. Can you read that Rehnquist concurrence again one more time?
Oh, I'd love to. So this is just a snippet, but according to the CNN article, Rehnquist attempted to advance a theory that would, quote, give complete power to state legislatures to control election practices. Again, legislatures. Elected people who are often campaigning. Give them complete power to control election practices at the expense of state courts, ensuring constitutional protections. So legislature would have the final say, not the courts interpreting.
Okay. That was actually helpful. I think the second time that I caught that. I mean, to begin with, the fact that the state, when you say state courts would no longer be determining constitutionality, are you talking state constitutionality or?
I believe so. That's a good question, but I'm pretty sure that they would be, because yes, federal courts would be interpreting federal constitutional questions. Okay. So yes.
So that was my teacher Kasey was coming out and was emphasizing the state, and I was like, wait, I wouldn't be surprised that Rehnquist would be saying this, but he was saying that state courts should determine like federal constitutionality, and I thought that on face value makes no sense. But also, of course, like the reason that the courts in both the state and the federal level interpret constitutionality is because that is their role. That is exactly what they were created for, and the courts are intended to be nonpartisan. We know in reality that doesn't happen. In some cases, they become extremely partisan. But that is the whole role of a court, and it's weird to just flip it on its head, as you said, because these people are constantly running for office, which means they are interested in money and campaigning, and I don't know, ripe for corruption.
I agree, and to be fair, in some states, judges are elected, so that could apply to them as well. But you're right about the functionality, that they're tasked to do a certain role rather than tasked to advance a partisan interest through making laws. They are like interpreting.
Did Rehnquist go to like civics class? Like legislation makes laws. They write and pass laws, and courts, judicial branch, interprets them and applies the law. What? Talking about changing the government.
Yes, right. Mix it all together. Blur that paint. Martin has given us a full circle imagery with his, it's an action that he's doing that I'm describing. Listen. So Martin, when you hear this theory, again, it was in the concurrence, so not in the majority opinion, but nonetheless, when you hear about the idea that state courts would have less power to ensure constitutional protections, does that make you think about the topics we covered in our first 2 episodes? Maybe the courts would not be addressing election laws and gerrymandering. Well, let me say that different. When you hear this theory from Justice Rehnquist, does it have you concerned that possibly courts would not be addressing things like election laws and gerrymandering, but in fact, that the people who would be doing said making of election laws and gerrymandering would be the ones who also would be arbitrating arbitrating whether they're accurate or fair or whatnot.
Yes, I'm glad you brought that up. There was a whole lot that you covered there, and I had thought about that for a second. It does sound similar to gerrymandering in that, in a lot of cases, gerrymandering is not people choosing the politicians, but the politicians choosing what people are part of their districts. So then they are constantly voted in. To bring back that sickening quote, it sounds like they'd be making the players the ones who make the rules. And in fact, they'd be making the players who won, right? Because they're the ones who are in seat. They would then make the rules. So what do you think happens? Those players want to stay playing. That's how they get paid. What are they going to do? They're going to make those rules
in their favor.
Mm-hmm.
So we bring this case up not only to illustrate how different the Rehnquist court was from the Warren court, but also just to show how these issues have contributed to how the pendulum has swung in terms of what the Supreme Court prioritizes and decides. And so, the Bush versus Gore issues have come up again more recently, including after the 2020 elections. So, Martin, those are some examples of past Supreme Courts. We didn't have time to cover them all, but we got into some good nitty-gritty, I think. Any reactions before we give our listeners a call to action?
Yes, I think maybe not. Let's go. We go with the. I think this might be part of my impassioned plea call to action. I guess. Okay, so if I were to say anything, it's well, I'm a law nerd and I care about the law. I think everyone should, because these decisions, just like a handful that we even just scratch the surface on, are so impactful into how we live our lives in this country. And right. I think particularly if we're talking about even just the Warren Court, or for all the good or the bad, or the Rehnquist Court for all the bad. And yes, I think these are people who were appointed and voted in by people 5 decades ago plus, and they have such an outsized impact on our lives today. Imagine
very true
how long the impact it would be for today. And I think if we can't sort of catch up and get things moving back in the right direction, we're in for some trouble.
Couldn't agree more. So I think that does relate to sort of our calls to action. One of them really is just being informed. We'll give you some more specifics though. So one thing you can do is visit the Supreme Court Historical Society page and check out the history of the courts. We'll provide a link to that page in our references that you'll find in the show notes. The descriptions of each court are pretty easy to read and they're not super long, so it's worth giving them a read. And of course, tune into our next episode where we'll talk about the current Supreme Court. And thank you to our listeners for tuning into today's episode. Check us out at Lawyer and Layman Pod on Instagram and Threads, and at Lawyer and Layman pretty much everywhere else. Let us know if there's any topics you'd like us to explain. Don't walk around not knowing.